legal aspects and liabilities in Ayush Center. I'm sure that is something that bothers everyone across the all the in the entire country, as to what are the different legalities and licenses and regulations that one needs to take care of. So Dr. Rajan sir is going to shed light on this topic. He is the senior manager, admin, and NABH coordinator at AVS hospitals and clinics. He has got more than 25 years of experience in hospital administration, including the corporate level, and 10 years additionally in the hospital quality journey as well. So, sir, over to you to enlighten us about the legal aspects and liabilities for any Ayush standard. Over to you, sir.
Very good evening to all. Thank you, Ms. Devasri, for the simple introduction. And thanks to Kaho for bringing up this platform, taking up Ayush also in the line again. Thanks to Dr. Shweta Suvarna, the organizing chairman of this program. And I acknowledge my esteemed institution, Kotak Ayurvedishala, for enabling me to sit in front of you or stand in front of you for that matter with this great subject. And my acknowledgements to NABH, who the organization which I revere more than any other organization, which actually guided me standing in front and making me an assessor, then a principal assessor, and then a faculty, and taking up the quality journey subject, that is legal aspects and liabilities in Ayush hospitals. The intent of my presentation, it's about 20-30 minutes. Discuss about the most important legal aspects connected with the hospital functioning, man, material, assets of all kind, records and milieu, patient and patient relations, customer and customer relations, medical negligence, billing connected, uniform care connected, taxes and levies, returns, etc., and something about the individual proprietorship, institution, and corporate. Before moving to the subject, these are the paradigm actually. Every person accused of a mistake is considered innocent until and unless he is proven guilty. Now, the onus of proving the innocence lies with the accused. So that is our legal system, and that is the base of the entire program head. Now, where are we? Which all legal angle and entanglements for that matter in Ayush or any other hospital? The following laws are applicable. Applicable are building and human building means the entire property connected with the land too. Laws applicable to institutions, laws applicable to personnel, laws applicable to sale, laws applicable to customer, laws applicable to clinical practice, laws applicable to income and connected activities, laws applicable to handling of hazardous, including chemicals and gas, what all, laws applicable to narcotics, all laws applicable to any other citizen and assets. So the entire spectrum of laws are applicable to the hospital also for information. Now we will move ahead with 2-3 in a typical standard way. Laws applicable to the property. The property means the land having the title, the land should be having a proper title deed, or it can be definitely a leasehold land, no problem. If it is a leasehold land, there should be a pakka lease agreement with the lessor. And before that, you need to take into consideration whether the land belongs to the special economic zone, coastal zone, ecologically fragile land, and all this to be verified before you take the land on lease. The building, whether it is owned or leasehold, can be operationalized as a hospital. If it is a leasehold, it should have a lease agreement. And before getting into a lease agreement, you must what you call proprietor or the concerned people must verify whether the tax receipts and the title deeds are in the name of the individual who is going to enter into the agreement. That's the most important thing. Otherwise, you will get into complications later. If it is a family property, you need to verify whether there is an assignment or that can be operated as a leasehold or in a title, whichever way it comes into. Then once the land part or you have the property right in front of you, you need to file an application to the local self-government department, which is your panchayat, municipality, corporation, or cantonment area, whatever be as per your area. Then for the NOC of construction of a building, if it is already constructed building, you need to have an NOC to convert it to an hospital, that is separately. And depending on the size of the building and the size of the bed strength or the size of the building or the area covered, and depending on the what you call the local rules, you may require a town planning clearance or a special economic zone clearance or coastal zone clearance, whatever be needed. The fire NOC for construction, before you starting a building, you need to have initial fire NOC or site NOC, it is called in that parlance. It is depending on 2-3 things. One is the national building code. Then there will be state rules for that. Apart from the national building code, depending on the fragility of the land and patterns of the state, there will be state rules. Then local self-government department can have their own rules, but not contravening the national rules. Of course, everyone knows it. And there will be town planning rules and the local rules by the other government, including DMO, such people may have rules. So these are all applicable to when you construct a small hospital or big hospital. The entire thing depends on the size of the hospital. Legality also depends on the size of the hospital. Then again, fire NOC as per the category of the building, and it depends upon the height in the area. Floors like say less than 15-meter height or less than 1000 m square, all these things are coming under one category. Then there are certain category which does not actually require fire NOC, maybe a fire certificate alone. So these all depends upon the fire department clearances which you need to apply for that. Then pollution control board clearance, that is air, water and biomedical waste management. So this we call it consent from pollution control department of the respective state. As per bed strength depends on occupancy certificate as per category. This local self-government or your panchayat municipality will be giving you an occupancy certificate, and the operation of the center or the hospital will depend upon the occupation certificate, occupancy certificate issued by the government authority on that. Electrical, depending on your power requirement, if transformer is needed, that has to be installed. If there is generator, that is to be approved by the state electricity board, depending on the strength of size of the capacity of the generator. Then again, if there is a lift, it has to be registered by the electrical regulating authority of the state. Then what all services you provide? You have only casualty or a simple 3, 5, 10 bedded Ayurvedic hospital. If you have an OT, that has its own requirements. If it is OT, you need to have HEV, HEPA facilities, ESSD, zoning, etc. As per the, and putting into the first part, that is the property building. These are the requirements before you plan a hospital to be kept in mind. And the entire spectrum of activity or thinking zone depends on the size of the hospital or the area of the hospital. And again, the state, the locality, all depends. Then we go to the registration. In registration, we have, as I said, there are 3 aspects of registration. One is the local self-government, where there you have a trade trade license. From state to state, there may be difference on all these aspects. This is a common name, trade license. Whatever you want to operate in a municipality or panchayat, you need to have a trade license or registration certificate, whatever it depends from state to state. Then in some state there is hospital and paramedical registration separately other than the trade license, that also required to be obtained. Then pharmacy license, retail, it again, this is all applicable in some states. This is not required for Ayurvedic hospital. If a doctor runs a clinic, so there is no requirement of a separate license, pharmacy license. These are also in parallel in some states, but in some states it definitely requires a license. Yeah, then food FSSA license for issuing food. So this is one. This is the licenses issued from the local self-government institute. After that is a state registration, state authority. The earlier one was local self-government or your panchayat or municipality. The next one is the state. There is Clinical Establishment Act registration as applicable, depends on your bed strength or your clinic. If it is a normal daycare clinic or one-man clinic, it all different clinic or different operational strength or structure has got different standard for registration under Clinical Establishment Act. If the act is implemented in the state, in most of the state now it is being implemented. In some states it's not. They have their own state rules. Shops and Commercial Establishment Actors or Level Department is another area where you need to have a registration. EPF and ESI as applicable according to your employee strength. Then in some state there is a district health authority registration or DMO registration is prevalent. So it all depends on the state to state for that matter. Pharmacy license as applicable from the state. SP7 license. This is for the sale of Aristasavas. In some state, it is prevalent that SP7 license has to be obtained from the state excise department. Then boiler, depending on your requirement, if you have a boiler, you need to have factories and boilers registration for boiler. Diesel, according to your requirement, if you have a diesel capacity of more than 300 liter any storage facility, you need to have a license from the explosive department. Medical gas, in case of a grid, if you have a gas grid being provided in your treatment room, you need to have a license for that. Blood bank is fit applicable, you need to have a license for that. Taxes, GST, etc. as applicable. And luxuries taxes again for the room rent. If the room rent is above 5,000, you need to pay luxury tax. So that is also applicable. Coming to the central registrations or the legal formalities connected with the central government, that comes under the operation of a clinical staff or establishment or hospital. Central government type is incorporation, whether it is a sole proprietorship or it is a limited liability partnership institution, if it is a private limited, public limited, trust or cooperative society, whatever the organizations, it has its own channel of registration. If it is cooperative society or a trust, it has to be registered under Concerned Cooperative Society Act, trust under Trust Acts, public limited company, private limited company, LLP, etc. under Joint Companies Act. So these are all the act to which the organization has to be registered. Then CGST to be registered. Institution PAN card has to be there to operationalize the hospital. Income tax registration is required. Depending on your requirement, whether if you are running an X-ray department, you need to register with the Directorate of Radiation Safety or Atomic Energy department. Even before thinking about it, you need to have a layout registration first, then post installation registration as applicable if you have the facility. And if you are what you call storing spirit, denatured spirit license is required. And as said earlier, if there is gas grid, storage of diesel above a particular quantity, 300 above and all, you need to have explosive license. PCPNDT for if you have ultrasonogram such test, and CM and all those things require separate licenses. Now we have covered the license part of it. How to start a hospital, what are the licenses required, that has been covered. Now we will come to the human factor, employees' rights, because the entire operation is carried over people, and there are laws of land actually controls the working hours. Protection against occupational hazard. Yes, if there is somebody working in electrical department, they need to have a boot, shoes. Then somewhere if there is gas related area, there should definitely be goggles and all those things. Occupational hazard, there should be machineries and equipments and devices present to take care of the occupational hazard. Safe working zone should be provided. If there is lift is required, lift is needed, and ramp required, ramp is needed, you need to establish accordingly. If there are doors required, windows, then all those things. This is about the facility. Now coming to the individual benefits, there should be every 6th day working, 7th day should be a holiday, a weekly off. There should be holidays established by the government. Of course, there are a lot of restrictions, regulations and relaxations depending upon organization to organization, all those matters. But these are the common requirements in any small or big hospital. Depending on the size of the hospital, it definitely varies, and the type of organization also, it varies based on that. You need to have a sick leave, you need to have earned leave, compensatory leave, special leave, etc. Then maternity benefits as applicable, compensation according to the laid down standard minimum wages are prescribed by the state government and central government also, so you need to follow that. Bonus as per the bonus act. And coming to the amenities for the staff, there should be drinking water facility should be there. There must be change room or restroom, etc., for the convenience. And there should be a mechanism for grievance redressal within the organization. And this POXO related issues, there should be a mechanism for raising complaints and grievances, especially with regard to the sexual abuse. And depending on the organization policy, there should be a policy on appointment of, in the case of dying in harness. So these are all basic things about the employees. And I'll just touch upon the minimum level of patient rights. Everyone knows about it. Just going through that in the quality initiative. Privacy of all kind. Individuals should be treated as a separate person. Even privacy from family, from what you call a wife, husband, and all those private, that privacy in a larger canvas, it should be seen. Uniform care, everyone is equal to according to their capacity. General ward means general ward. You can't differentiate because he's in bed number 3, he should be given a little more extra care. No, general ward, general ward. Again, if it is a what you call super luxury, super luxury, so charging is different. Differently you can provide different services. That is a different aspect. But wherever, whatever criteria put into, there should be a uniform care. And patient has the right to have the estimate of his treatment, if it is for 10 days, 14 days, the category of room applied to, the line of approach treatment. But it will definitely not be a precise figure. It will be an approximate. So you need to mention that this is an approximate, have it conveyed to the patient, so that at the last moment while settling the bill, the patient will not say amko malum nahi, I don't know. So that situation should not arise. That is why right to estimate, every service should be billed, and every receipt should be every payment should be receipted. That is one another aspect. Patient should be briefed about the care plan, what is going to happen when you examine the patient, in which line of treatment you are putting him on. All informations and briefings and connected inputs about the therapy must be shared with the patients. And you can change it, there is no issue, but you should have the consent of the patient, or at least should be known to the patient for that matter. This I am, though I have started initially with this line of therapy, because of your non reaction or overreaction to the particular line of therapy, I am changing it, or the medicine reaction, whatever be. So there is no issue, but it has to be informed to the patient, black and white. Patient has all the right to deny a treatment because of his own, say maybe you apply a potly with a meat. Patient may not like it because of his own individual reservations, and then patient can deny it. But definitely it should be told to the patient the benefit of it, and they can deny it. And when they deny it, in that, if the doctor feels that for a safer side, you can take an undertaking also. But all these things should be witnessed. Ideally it should be witnessed. And the patient has the right to be referred to another doctor, or he has the right to seek a second opinion, which should be welcomed by any treating physician. Consent is the most important aspect. The consent can be of general consent, to getting into the hospital. You need to, for a general consent for any other intervention, anything, there can be a general consent. Procedure specific. If it is going to be a Vasti, there should be a Vasti consent. If it is going to be a Thailadhara, there should be a consent on that. So specifically therapy related procedure specific. If it is anorectal procedure, you need to have a consent for that separately. And any activity taking place in connection with the research, when you treat a patient, there should be a separate consent. If you plan to public, or if you plan to publicize something or public what you call videograph, photograph of anything of activity concerned with the patient, then naturally there should be a separate consent from the patient. And ideally it is good to the organization if it is approved by the legal hire or others as witness. And if the consent cannot be given by because of his inherent problem, or if the patient is unconscious, the patient is unable to give a consent on in his own, naturally the consent can be taken by the legal hire or the witness who be. Then patient has the right to get all the medical documents, including investigation reports. So there is no need of a separate request for that. All especially for investigation reports, that once the patient is paying for that, you need to provide the report. So there is no separate request for a report for that matter. Certificates and reimbursement forms additional. A patient has all the right to get his certificate, medical certificate, discharge summary, or one or two certificate which is to be given by you or the treating doctor. That has to be given, provided with the separate request. The patient can definitely ask for a certificate. You need to have a written request for that. Based on that, the certificate can be issued, and this copy of certificate should be kept with the organization or the doctor for further reference in case of any legal entanglement in the later stage. And if the patient wants one more or two copy of certificate, you can give one or two copy for that, but it should be marked as a copy and signed separately. There is only one certificate. Additional copies are either duplicate or a copy. So that has to be kept in mind before issuing another certificate of the same kind. So patient has the right to get the pain relieved. You cannot tell the patient that because of this treatment you will have the pain and you are supposed to be rid. No, patient has the pain management is an important criteria in the entire patient management. So you need to, I mean, wherever if it is beyond the scope of the organization or the doctor specialty, you need to approach the higher pain relieving measures for that matter, whichever is applicable available. So that is about the rights of the patients. Doctor-patient relationship, I'll just touch upon that. It's a fiduciary right. That means the trust, loyalty, confidence, and dependability is a mutual relation. Like the patient comes to the doctor with a firm belief that he will take care of me, and the doctor is supposed to respect that in all trust, in all his dependability, and convince the patient that I am here to treat you. So, and the patient comes in. So that it's a fiduciary right, or it's a fiduciary relation between the patient and the doctor. So these are the kind of relation: paternal relation, informative relation. These are some just typical what you call subject for discussion. I'll just touch upon paternal. Means like the doctor behaves like a father, where the patient obeys like a it's an obedient child. He takes carry forward the instructions by the doctor. Informative means he shares all the information available and then convinces the patient this is the management. Interpretive means patient shows this is how it is look like, Vasti is like this, or Tarpanam is like this, whatever be. So interpretation makes the patient convince and then forward. Deliberate, the patient issues, doctor issues lot of data to the patient also gives some data, and they deliberate each other and comes to a conclusion regarding the treatment. This is just touching on that aspect for information, please. Now, why litigation happens? Legal liabilities comes in with the naturally litigation. The reason is very simple. You need to accountability is the most important factor behind this litigation. There should be somebody accountable when there is a mistake happens. And number two, there should be explanation for this, because you need to know, I mean, the public need to know, the patient need to know, the public need to know what has happened exactly, and the legal system should also know. So that is another aspect. Other one is expected standard, because if there is no litigation, if there is no reason, I mean, no liability fixed, there will not be standard. There should expected standard is there, or a standard should be evolved. If there is no standard, because of this mistake, a standard has to be evolved. So standard is necessity, and naturally compensation. If some mistake happens, the patient or the victim should be compensated. So these are the three, four common factors which leads to the need, which actually gives rise to the litigation. Um, it's another important thing that patient population established at first stage, like love at first sight, it is said so. So the same way, when a patient meets a doctor, the relation starts. Whether you like it or not, it is the duty of the doctor to take care of the patient, and the relation starts then and there. And that relation evolves into or broadens up with two, three things like contractual. Contractual, it becomes a contractual relation because you are charging or not charging, another issue, totally different, I think, which should be a little more discussed a little wider. And there is a consensual, because you take the consent from the patient, it's a mutual consent that happens. Then trust based, mutual trust also is involved in this. Another important, ignorance law of law, everyone knows it, specifically mentioning it's not an excuse. And as a responsible citizen of all kind, especially doctor community or the hospital institution as an institution is supposed to provide care as a responsible individual, as a responsible institution. Eyes do not see what the mind does not know. That is another. The mind should be kept alert in all. Mind means entire operational areas of the hospital should be kept alert always to know what is happening in and around. So there lies, or these are the important aspects when you talk about why there is a litigation happening. Now, medical negligence is another area where we should be touching upon on this liabilities and responsibilities. Doctor is duty bound to care. He's taken the oath to care the public, so naturally he's duty bound. So otherwise it becomes, let us put it in blunt language, dereliction of duty. So that is one aspect. And because of his care, there is a resultant injury, and all those things happening. Then you are responsible. Then diagnosis related, if the diagnosis is not proper, like pre-eclampsia and things like that, where I am not going detail about it. So these are all the diagnosis related issues which can definitely cause the medical negligences. Advice and counseling related, where the doctor is supposed to advise the patient, counsel the patient for his relief and things like that, that is also to be taken into account. Then treatment, or the most important part is treatment or management related issues, which comes up in the heading of medical negligence. Care and cure, skill, specialist knowledge, competency, all these factors that when you advertise, or when you say I'm a medical doctor, so and so qualification, you are supposed to render that care, that quality, that skill to the patient. If it is not there, it is a negligence from your side. Competency is another area. If you say I am a phytologist, then you must be able to exemplify or reflect it to the public that yes, it is happening. So otherwise it becomes a medical negligence. Lack of facility, because if you say there is a labor department, if you don't have a table, if there is a gynec department, you don't have a required table, a litho table and such things, all the facility as required per department should be available, otherwise it becomes a negligence. Medico legal things a doctor should be taking care of is consultation is a medico legal aspect, where duties, medico legal duties, consultation of patient is a medico legal duty. Anything goes wrong, you are suable. Document, whatever documents, OP document, IP document, certificates, bill, receipt, whatever is documentation related is a responsibility. Preservation is supposed to be preserving all these things, or as per the law, all these things should be preserved. Intimation to government authorities, suppose if there is a 8 case just to 8 case admitted, or a case coming under national list of diseases which should be communicable disease or such things, where it has to be intimated to the health authorities, that has to be intimated. And dying declaration to be taken from a patient has to be taken. Then declaration of death from our hospital, if it is, then how is it done? If that is a medical legal aspect, where a responsibility, duty of the doctor. There are 2 3 law, tort law, criminal law, all applicable to the doctor fraternity or the hospital. Now, a little more adding to it, vicarious liability comes under the head of the institution where the doctor runs a hospital. A mistake done by the staff is a vicarious responsibility or liability of the doctor or the institution as such. If he is the sole proprietor, then he is definitely liable. So that is the vicarious liability of the institute. Then insurance documents, one or now there are this time less little to say. The patient may have 2 3 insurances. Patient may have 2 3 insurance coverages, and patients is lab definitely it is his right to get 1 or 2 insurance forms signed. Now you cannot deny, no, I have signed A insurance companies, I will not sign B. But the what can have kept as a check and balances, all the discharge summary, all the receipts, all the bills will be issued one, and next is copy or duplicate. So that is the safest thing which can be done, but you cannot deny giving 1 or 2 forms signed. But please do keep a copy of every document issued to the patient. No document should be issued without keeping a copy with you, and also ideally taking a signature, received signature from the beneficiary. Responsibility article 51 we already discussed. Engaging unqualified person is also an offense. So that is also be, if you are running a therapy, you should have a qualified therapy center, you should have a qualified therapist under your payroll, and you can definitely have trainees. That is altogether a different issue, but the therapist should be there trained. Not having required equipment and facilities is another offense. So need not mention much about it. Whatever facility you are supposed to be keeping in your scope of services must be available in your center when a patient comes to enter into the hospital. All these things, I mean, just for information, Hammurabi is very old. From the Mesopotamian style onwards, there is a patient doctor relation. It is coded then onwards, and in we as Ayurveda people knows about Sadvrta, Chadushpada, Vaidyavriti, Acharya Rasayana, all this mentioned about patient relations, doctor relation, and the requirement of a patient in elaborate. So within my this short span of time, I think I have covered the minimum basic requirement concerning the legal issues and the liabilities concerned with the clinical practice. And further, if any, definitely could be handled by the expert panels again with me in the panel. So that is about the subject as of now. Thank you all for the patient hearing.
Well, thank you so much, Rajan sir, for the insight about the various aspects, the legalities, legislations. What are the reasons